Hey all, welcome back to the Law Read Slowly, and in this series we're discussing the Code of Civil Procedure 1908 in a slow and steady fashion by focusing on the text of the legislation in the context of the case laws. So in the past few sessions we have discussed upon the nature of the code. I have tried to make you more familiar with the structure of the code. I have made code a little less scary for you, making you understand that the Code of Civil Procedure is no different than any other law that you employ in the courtrooms or in a classroom or in an evaluative setting. So it shouldn't be something that should scare you. It should be something that you should regard at par with any other law, and you have seen with ample amounts of time spent, we have understood the purpose of Code of Civil Procedure, and we've seen what is it trying to do in the society. It's trying to govern the civil legal relations in a civilized society, and its purpose is to serve the ends of justice. And we have seen a number of ideals and principles that govern the Code of Civil Procedure, which try to sharpen the edges of civil procedure wherever it appears to be defeating justice. We saw the maxim that procedure is the handmaid of justice and not its mistress, which we discussed amply. We also took some examples to see when does this maxim come into effect. We saw how constitutional ideals are ingrained in the Code of Civil Procedure and how they make the code itself effective. We also took down a long dictation on all that we had discussed. This choice to make you write whatever we are discussing also stems from a number of questions that I have received from a lot of you who have asked that if I could also help them put down the discussion in a manner that they can actually use. And a lot of you all have been asking the way to improve your communication skills, the way to improve the way that you speak about law, the way that you express your views and opinions on the law, and that you were looking, while you were finding the discussions very engaging, but you would also like a way to be able to put all of that into a narrative and to have some diction, some terminology to use. So the first and foremost suggestion would be read as much as you can, because the better stock that your mind has, the better output it will be able to give. Because if the blueprint is full of good amounts of stuff read, good quality of things read, reading scholars, reading legal professionals, reading judgments, then all of that is what is going to be in your mind. And whenever you put a question on the law, your mind will automatically return to that repository for an answer. And the answer itself is going to be eloquent. The answer itself is going to be full of good legal terminology when that's what you've been reading. So that's why I decided to give you a dictation on whatever we are discussing, so that you know how would you be writing it if you were to write it, whatever we have discussed in the past sessions. Now use that as a blueprint and try to write your notes and take down your notes during the sessions in that fashion. Try to employ the language, try to employ your own style of writing so that you become familiar with the skill of writing about the law as well. So today we will proceed. We will begin with the topic of plaint, and we might or might not complete it in this session, but we will either ways. We're going to go at a steady pace that ensures good learning of the concept rather than rushing through it. So let's begin first by understanding the trajectory of a suit that we have laid down, and from there I will take you into plaint and then focus our discussion on the plaint itself. And in that streamlined discussions, we will pick a number of topics to look at the concept of plaint from different angles. We will look at legal provisions. I will flag some questions for you. We will see what are the components of a plaint, where are these components provided in the code itself. We will be relying on Order 6, we'll be relying on Order 7. We've also looked at, then we will also see why do you have a plaint, what says that a plaint needs to be filed in a suit. We have seen that provision briefly. Section 26, read with Order 4 of CPC, is telling you how will a suit be instituted. And I also briefly told you that whenever you are instituting a suit, while the code says that you need to file a plaint, it is not that you can only file a plaint to start a suit. A suit can be started even by other sorts of pleadings. What can they be? It can be a petition. It can even be an application. For example, for divorce, under Hindu law, you have a divorce petition that is filed. Okay, in Indian Succession Act, 1925, you don't have a plaint. In arbitration law, if you want to start a civil suit with respect to the award passed by the arbitrator, you don't file a plaint, you file an application there. So all of these are nomenclature, but they are all playing the same function. So whenever, if you're talking about the way that a petition is drafted, then the same rules that are applicable to a plaint will also be applicable to that petition. It will have to meet all the requirements, like having a cause of action, mentioning the material facts, not mentioning the evidence. I'm flagging all of this, but we are yet to discuss it all. So if it appears a little alien or unheard of to you, it's fine, because it is. And we will discuss this in detail with legal provisions as we proceed today. So it should have a verification, it should have a statement of truth, that is an affidavit. So we will see what is this affidavit, what is verification, where does it come in a plaint, does it come at the start, does it come towards the end, what is its purpose. We will see all of that. So let's begin. So we have discussed the trajectory of a suit. The trajectory of a suit. How does the suit proceed? So it starts from a cause of action. We have a cause of action. Why do we need a cause of action? Otherwise it will lead to rejection of plaint. If the cause of action is not there, then a plaint will be rejected outrightly. As per what? Order 7, Rule 11A of CPC. After cause of action, what is the next step? Next step is plaint. Plaint has to be filed. For plaint, what do we have? We have order 6 plus order 7 of CPC. Why do we have these two orders? Because this is dealing with pleadings in general, and pleadings is an umbrella term for plaint, written statement, and all other kinds of pleadings that are filed by both the parties. Order 7, this is directly dealing with plaint. Then after plaint, summons will be served to the defendant. Where is summons? Order 5. I'm only flagging them at this point, so you also learn to do this exercise whenever you are yourself reading your notes, and if you spot a spot where you don't have a provision mentioned but you have some name and the provision is in your mind, mention it there. And if you want, you can go back to the Bare Act, look at where that provision was or where that concept was spoken about, and mention the provision there. So we have summons. After summons, written statement. Written statement is governed by order 6 plus order 8 of CPC. Why? This is for pleadings, and this is for your written statement, which I'm writing as WS. After written statement, what do you have? Written statement has come, summons was served, written statement is filed. Then you have first date of hearing. Where is this? Order 10. Order 10. After first date of hearing, what do you have? You have ADR. Actually, this is part of it. Remember when we discussed, we made 7A. So ADR is under Order 10, read with Section 89 of CPC. If ADR is not done or it's failed, then what? Then we have settlement of issues. Settlement of issues is under what? Order 14 of CPC. Settlement of issues. Then after settlement of issues, we have what? Trial. Trial begins. Trial has many steps. We have seen a lot of things can happen in trial. But one section, if you were to write, one provision that you were to write, you would write Order 18 of CPC. It tells you how the trial is to be conducted, who will begin, who will give their evidences first, then whose evidences will follow, Otherwise, you have a number of things that can happen in trial, which I will not go into right now because we have already discussed this at length. Then, after trial has begun, arguments are happening. So you have, so see, in trial, what are you doing? You have arguments, you had evidence, you can have adjournment. Then what else you can have in this? You can have applications can get filed for different things, maybe for interim injunction, etc. After all of this has happened, next stage is judgment plus decree. Where did we see this? Section 2 clause 14 provides you a definition of a judgment. 2 clause 2 CPC provides you a definition of decree. Just keep mentioning this if you're mentioning it. So this is the stage. After this, what do you have? You have two parts, right? Decree holder and judgment debtor. What will he do? Execution. What will this person do? Appeal or review. Correct? So this is how a suit proceeds. I hope you remember this. We have cause of action. Then we have plaint, then summons, then written statement, then first date of hearing, where they will check if ADR is possible. If ADR is possible, they will be sent to ADR. If ADR is not possible, they will be going to the next stage, which is settlement of issues. Settlement of issues is where the questions get drafted on which the suit will proceed. It is under order 14, and after settlement of issues, the issues have been settled. So now you can fight on them, you can start arguing on them, you can start giving your evidences on it. So you will have trial. This is all the process of trial. We have a long process of trial where a number of things can happen. After trial, what will come out? A judgment and a decree will come out. A judgment is also governed by order 20, which is directly dealing with judgment and decree. Order 20 of CPC. Definitions are here. Order section 2 clause 14, section 2 subsection 2. These are the definitions. This is the order governing. This gives you rules as to how should a judgment be drafted and what all should go into a judgment, how should it be pronounced. Then after judgment and decree, you have what? You will have your execution for decree holder, appeal or review. Be wary of this review. Be very careful. It can be only one of these. You can't go in appeal also and the review also simultaneously. We've already discussed it. Why? So that is the procedure of how a civil suit proceeds. So we have seen two terms. One is suit and the other now is plaint. A lot of people, when they are discussing suit, plaint, or when they're thinking about it in their mind, they tend to confuse it. They tend to confuse these two. They tend to use the term plaint and the term suit interchangeably, which is absolutely wrong. This cannot be done. It's wrong. These are two different things, completely different things. But it's very simple. If you look at the trajectory that we have seen, what is suit? Suit is everything from cause of action to your appeal review. This is suit. So suit is a set of proceedings. These are all proceedings, right? Filing of plaint, summons, first date of hearing, written statement, ADR, settlement of issues, trial, judgment decree, and then finally your execution, appeal, review. These are all proceedings. So what is a suit? A suit is going to be simply a set of proceedings. Is suit a document? No. Case file is a document. Is suit itself a document? Is suit itself something tangible that you can hold in your hand? No. Suit is a set of proceedings. And we have seen all the proceedings that happen in a suit. But what is a plaint? Plaint is a pleading. Plaint is a pleading, which is what? It is a proceeding. It is one of the proceedings that happen in a suit. which is one of the proceedings that happens in a suit. Plaint is something tangible. Plaint is printed on a paper. Plaint is a document. So plaint is something tangible. Plaint is a pleading. Plaint. So you can say that plaint is what kicks off a suit. Will I be wrong in saying that? That plaint is what kicks off a suit. Plaint is the foundation of a suit. Plaint is the initiation. Plaint is the initiation of a suit.